So a psychosocial hazard, and the reason that that whole term got created is it's wanting to acknowledge that there's things within our work environment. So sometimes it might be systems or structures or processes or the actual environment, or it might be people and how they interact with each other, and they cause a risk of psychological harm to people. Can definitely, all of those behaviors can also cause physical harm, but the reason how they created this term psychosocial hazards was because of psychological harm. So psychosocial hazards and psychosocial risks are buddies with each other. So many of you in WA, and I know you have other codes of practices throughout Australia, but this in our code of practice, so psychosocial hazards comes under our safety legislation. It's a code of practice, and there's 20 categories that they identified in that code of practice. And this is a snapshot of what those 20 hazards are. So hazards can cause risks, and that's how they relate to each other. A risk can be arising from a psychosocial hazard. And so that's our very simple framework of those terminology. In terms of just getting a really quick snapshot of Australia and what's happening, and really there's been a wave. And so back, if we go to New South Wales back in 2021, who were the first state who created a code of practice, and often the codes and regulations have gone hand in hand with each other. Sometimes the code have come first and then they've created some regulations to go with it. But you'll see all over Australia, and Victoria is our last. It's kind of interesting that Victoria is our last state that will have a code of practice by December this year, because actually when we come and have a look at the prosecutions that I'm going to be talking about, many of the prosecutions are actually in Victoria. And so I think it's worth saying that even before these codes of practices existed, there still was the language of psychosocial hazard. And I'll mention that later when I talk about an improvement notice that was issued back in 2018 to a workplace in WA before we had a code of practice on psychosocial hazards, and yet they used the language of psychosocial hazards in that improvement notice. I think what the codes and the regulations now give us is greater clarity. So they give us a really clear framework around what does constitute psychosocial hazards. And they also give us a framework about what they want us to do about them. So that's big picture psychosocial hazards. Just going to now do a bit of big picture on sexual harassment, because we said we'd be looking at case law related to both of those areas, and in terms of what WorkSafe have been doing in prosecuting them. So every state and territory has a definition of sexual harassment. WA, and most of us are in WA, our definition is old and antiquated and is supposed to have been changed about 3 years ago, but has not yet been changed. I am giving you the federal definition of sexual harassment, which is also the same definition in every other state and territory in Australia, because that is the definition that the recommendations for the WA Equal Opportunity Act have been to go towards it. Also, this definition is easier to prove. So if you use this definition as your benchmark, then you're not ever going to do something that breaches our WA definition. And it's broadly speaking, there's three components. It's got to be unwelcome conduct. It's got to be of a sexual nature, and the definition explains subcategories of that, but broadly speaking, sexual nature. And the courts have created a hypothetical, imaginary, reasonable person. Their job is to look at the behaviour complained of and say, is it possible that someone could be offended or humiliated or intimidated? Now, that definition has been the domain and owned fair and squarely by our equal opportunity legislation since the 1980s. It's not a new definition, and apart from WA where it needs to change, it hasn't really changed much over that period of time. What has changed is safety's ownership or claiming that definition, or more specifically, claiming those behaviours from a safety perspective. And while now we might think, well, it's so obvious that sexual harassment is a safety issue, I've been working in this space for 16 years, and I'm telling you, 5 years ago, it was not articulated as a safety issue. In fact, when I was going back and doing some research in preparation for this webinar, the first kind of information that I could find, and that came through our national safety body, Safe Work Australia, was back in 2021. when they issued some guidelines related to sexual harassment from a safety perspective. Since then, things have accelerated pretty quickly in relation to WorkSafe and sexual harassment. So, back in December 2023, national body Safe Work Australia created a model code of practice, and it was called the Model Code of Practice on Sexual Harassment and Gender-Based Harassment. And what's happened with that code of practice is that since then, it's now been adopted by some of our states and territories. So New South Wales adopted it in June 2024, ACT in August, Queensland in March 2025, Tasmania in June 2024, the Commonwealth in March 2025, and Northern Territory in May 2024. So we actually in WA haven't adopted that specific code of practice. Having said that, back in early 2022, when our safety laws finally got harmonised with most of the rest of Australia, Victoria still haven't done it, but everybody else has. What also was created was a code of practice on workplace behaviours. And in that code of practice on workplace behaviours in WA, it clearly identifies sexual harassment as a behaviour that fits within that code. So it has identified sexual harassment as a safety issue, as an unsafe work practice. What it didn't do is it didn't identify sex-based harassment in that code. Now, sex-based harassment only actually came through our federal legislation in September 2021. Our new code came out early 2022. I don't know if that's why they didn't put it into the code. I'm going to say I think by inference, both because of the model code of practice, both what we're seeing happening in Australia, that I would say sex-based harassment would also come within the protection and considered it to be an unsafe work practice. But currently WA haven't adopted that code of practice related to sexual harassment and gender-based harassment. But again, and I think what you can see from my map is that the movement around adopting that code has actually been a lot quicker than the movement around adopting the code on psychosocial hazards. Also good to say, at least within WA, though, it would be similar to the other codes of practice around psychosocial hazards, that unlawful behaviours such as sexual harassment and sex-based harassment are also a psychosocial hazard. So whether you've adopted this specific code on sexual harassment and sex-based harassment, or you have adopted the broader code on psychosocial hazards, it'll fit within one of those places. My best guess as to why we have this now code of practice on sexual harassment under safety is really to shine the light on it, to draw greater attention to it, to give people information and frameworks in terms of what they can do about it. All right, so with all of that in mind, we now put our safety lens over all of those behaviours that we just talked about. So specifically in Queensland, New South Wales and WA, they've actually outlined in our legislation that there's a 4-step process that a PCBU, I'm going to just call them an employer, but it is slightly bigger than that an employer has to do. So they've got to show that they are doing all that's reasonably practicable to eliminate those behaviours, or in fact to do that 4-step process of those behaviours. So everything related to psychosocial hazards, those 20 categories, plus sexual harassment, which is actually number 16 out of those 20 categories. So they need to be able to identify. So our starting up is what are hazards that are relevant to our workplace. So they need to actually be able, on a macro level, be looking at that. They need to then assess it. So that's that weighing up where they go, how real, how relevant, how likely, what's the consequences if these kind of behaviours happen to us. And then they've got to work out what are we going to do to stop that. Now, safety talks about a hierarchy of control. And so what they're saying is, look, best, if you can, we want you to show us what you can do to stop it. So that's your number one option. But we understand that sometimes you can't stop those behaviours. And so what are you doing to demonstrate that you've minimised that behaviour as best as you can? And then the last bit is maintain and review. So that's what we talk about, that continuous improvement process. So is it working? Has anything else happened? Is there anything else we should be doing. So that's the framework that our safety laws expect a PCBU to do. So what happens if they don't do it is a whole range of consequences, legal consequences that WorkSafe has under our Work Health and Safety Act. And some of you might be familiar with some of these consequences, some of them you might not be so familiar about. So one of the things is that if it's a notifiable incident, and that's where someone has taken more than 10 days absence, and it's related to, there's categories in there, but it's related to a psychosocial hazard, then you need to notify WorkSafe. And actually you can be prosecuted if you haven't notified them of that. They can issue improvement notices, and we're going to have a little bit of a look in a few minutes about some examples of improvement notices that were issued by WorkSafe in relation to, we're looking specifically around psychosocial hazards or sexual harassment. Of course, they can prosecute, and so again, we're going to look at some of those prosecutions. They can impose pretty substantial fines, and then they can impose imprisonment as well. Yes, someone just asked me, is it 10 work days? I think it's 10 work days is my understanding in relation to that question of the 10 days. So so prosecution, so fine and imprisonment, well, again, we'll look a little bit at that. There's also an enforceable undertaking. I'll explain that a little bit more later, but that's basically where instead of being prosecuted, you pay WorkSafe money, and then that money gets allocated towards going towards training and other programs that WorkSafe deems is appropriate to improve the safety in workplaces. But then there's some other non-pecuniary sanctions. So adverse publicity orders, training orders, and restoration orders. So that's around how can we kind of fix things up, sort things out. So a lot of consequences. Also, not through WorkSafe, but there was a couple of cases that I thought was worth bringing to your attention. People can also make a workers' compensation claim related to psychological injury. People can also sue their employer, usually in negligence or breach of contract for psychological injury. And so there's a case of each of those that I'm going to talk with you about as well. The starting point to understand is even though safety has created these regulations in which they identify psychosocial hazards, when WorkSafe gets involved and decides to intervene in any of those ways I've mentioned, but probably specifically in relation to a prosecution, they're not doing it actually through the part in the regulation related to psychosocial hazards. They're doing it through your Section 19, or in WH Section 19, which is they globally say that the PCBU has failed to provide and maintain a safe workplace for workers. And so it's important to just understand that's the avenue or the door through which WorkSafe can commence a prosecution. It's through the Section 19. And then they will collect the evidence that may then be relevant to psychosocial hazards, but they're using Section 19 as the basis of that intervention. All right, penalties. So, and it does vary a little bit, but here just gives you an example of kind of what fines can look like. So if it's proven that a PCBU was reckless or grossly negligent and exposed their people to a serious risk, up to a $3 million fine. If it's not reckless but exposed to a serious risk, up to 1.5 million, and if they weren't exposed to a serious risk, up to 500K. Yes. Can people just mute yourself apart from me? Hopefully you're wanting to listen to me, but you probably don't want to listen to anyone else's conversation. So just to give you a sense of the kind of penalties that we're looking at. And look, here's an understanding. So when WorkSafe comes into your workplace and conducts an investigation, when they're doing that investigation, and if they issue improvement notices or other non-pecuniary actions, the standard of proof that they're operating on is at what we call our civil standards, so our balance of probabilities. When it goes to a prosecution then becomes a criminal matter. It's normally heard within the magistrate's court, and that now changes the standard to a criminal standard, which is beyond a reasonable doubt. So anytime a court is looking at imposing fines or imprisonment, then what they're saying is, look, we're really needing to make sure that this has happened to a higher standard of proof because of the consequences, right? As you can imagine, they are really serious consequences. All right, so let's have a look at some prosecutions. Now, the first thing to say about WorkSafe prosecutions is because they operate in the magistrate's court, we don't get a transcript of it. And so the only way we tend to find out that something was prosecuted is if the media gets hold of it or if WorkSafe releases a media bulletin saying we've prosecuted and here's what's happened. So I can't go into all the nitty-gritty details of these prosecutions because all I've got is what WorkSafe released, but it's worth, let's have a look at them. So actually just recently, so in May 2025, and again, I think I said to you at the very beginning, Victoria doesn't yet have their code of practice on psychosocial hazards, and yet 3 of the prosecutions that I have found in relation to this space is in Victoria. So we already have enough of a framework before it happened. It's probably more about, for many of our states and territories, giving us greater clarity about psychosocial hazards. So this case here, and again, I can only go on the notes that I was given. So a worker made a complaint, and actually it was one of the directors of the company that had been making comments and sending messages to her about her personal life, and there was a whole lot of information around it in a sexual nature. WorkSafe did an investigation, and so these behaviours occurred around 2022, 2023, which in the scheme of complaints and investigations and prosecutions is actually pretty recent. And what happened was, what WorkSafe said is that that organisation, obviously they failed to provide and maintain a safe workplace. That's our umbrella statement that they say if a prosecution is successful. But what they said is they had no formal system in place. So they had nothing in place to identify, prevent, manage, investigate, respond to a complaint. That they had done no training related to unacceptable behaviours, and they didn't have a workplace policy around it. And in fact, this decision was made in the absence of the director. So there's a legal principle called ex parte hearings. So if you try and get the person there and they don't turn up after a certain amount of time, you can just hear it in their absence. So, and actually, when I was reading about this case, the director and that company had gone into receivership as well. So I'm not sure if they're going to get the money out of them, but this is an example where really they had done nothing, and kind of to the point where they didn't even turn up in court to argue, defend, plead guilty, like nothing. So that's one of our most recent ones, but we don't know more about what the behaviours were, except that they fitted within the space of a sexual nature. So clearly they would have constituted sexual harassment. In WA, that's number 16 on our code of practice. But it's, as I've mentioned, because of that model code of practice related to sexual harassment, it's very well accepted that WorkSafe can deal with it. It's also accepted that it's a psychosocial hazard. So case number 2, again, Victoria, and this actually was the Court Services Victoria. Bear with me, just got all my notes here. So this was an example where there was a whole lot of behaviours that had extended over a few years. So I'm just going back. So from December 2015 to September 2018. So we're looking at a long time, and the case was only finally heard in 2023. Unfortunately, I just hate saying this, but this is probably more realistic in terms of the length of time that it takes before matters are surfaced, investigated, and end up in a prosecution. And from my perspective, I think about the people's lives that have been traumatized throughout that whole experience of what was happening to them. And unfortunately, and I don't know if this is what actually triggered finally WorkSafe getting involved, but one of the people who was one of the principal in-house solicitors at the time at Court Victoria died by suicide as a consequence of all of the behaviours that had happened. And so when WorkSafe did that prosecution, they identified a range of things. So exposure to traumatic events. So that's clearly identified as a psychosocial hazard. in WA, we break it down to first responder trauma, secondary trauma, and vicarious trauma. Also, there was a very high workload and work demands, again in WA, and it's pretty accepted throughout Australia that workload and work demands is a well-known psychosocial hazard. And also that there was poor working relationships between people, high conflict and inappropriate behaviours. So there was multiple behaviours that fit within the broader terminology of psychosocial hazards that were investigated. And perhaps that's reflected in the fine that was imposed on Court Services Victoria of $380,000. We then have another case, Victoria again. This one, I mean, when I read it, and it really looked like WorkSafe just threw the book at this company and the director. So it was the sole director of the company, Whitlam. He was also the manager and the boss of the workplace. He ran cafes in hospitals. He hired young women, often between the age of 16 and 18. And over a period of, so it started back, the behaviour stretched back to 2014, and WorkSafe conducted an investigation in 2021. So for 7 years, the evidence suggested that he had been acting in actually a sexually predatory manner and behaviour to these young women, and a whole raft of sexually inappropriate behaviours to them. And so when they did the investigation and they prosecuted him, they prosecuted his company, which he was the sole director of. They prosecuted him, and they prosecuted because he was also the manager. So they basically went in every pathway possible. And he had two companies or two different hospitals that the cafes were in. And so they fined him twice. And so the collective fine for those behaviours was $250,000. As I mentioned, spanned over seven years, so quite an extended period of time. Again, we didn't have a code of practice on psychosocial hazards back down in 2014, but that didn't stop them from doing this prosecution through the lens of psychosocial hazards. And again, sexual harassment historically would have been dealt with through the Equal Opportunity Commission, but in this situation, WorkSafe also dealt it. So that's three cases, probably of the more significant ones I found in relation to prosecutions. Some of you in WA may be aware that Department of Justice is currently going through or are currently being in the midst of a prosecution related to allegations of bullying, sexual harassment and victimisation at Bunbury Prison, and that the catalyst for that was a female prison officer. What happens when we go through a prosecution or any kind of WorkSafe investigation is that there may be a person who's the catalyst for that starting, but they are not the complainant. So just to understand from a legal perspective, WorkSafe don't represent individuals. Their job is to ensure that it's a safe workplace, but someone may be the catalyst or the trigger for WorkSafe deciding to conduct an investigation. So in this situation, it was a female prison officer, but WorkSafe will be conducting an investigation, again, back to whether it's unsafe work practices that's happening. So that's ongoing. From what I had read, I couldn't find anything more recent. The Department of Justice was in the Magistrates Court back in November last year, and it's set for a hearing, but I don't know any more about where that's at. So that's some prosecution. So that's where WorkSafe has ownership of them. They're doing the investigation. It ends up in a magistrate's court, can result in fines and imprisonment. But there's other actions, and I thought it was worth you hearing about a few others. So improvement notices, and some of you may be aware of what they are, but when WorkSafe comes in and conducts an investigation, if they decide that there's some unsafe work practice that have happened there, then they can issue the PCBU an improvement notice or multiple improvement notices. And this is, in effect, you have to do things. Often it's related to training, updating policies and procedures, so things like that, but that's the kind of stuff. So when I was having a look across Australia for some improvement notices, again, we're looking in the space of psychosocial hazards and then more specifically sexual harassment. There was an example back in 2024. So, New South Wales, a workplace called Women's Trauma Recovery Centre, they were issued 3 improvement notices related to exposure to psychosocial hazards. And the ones that were identified were excessive workload, poor job clarity, poor working relationships, inadequate information and training about vicarious trauma. And there's another case I'm going to talk about in terms of trauma and vicarious trauma in a moment. For those of you that work in a space for which that is a live issue, it is so important, not just from you need to care for your people, but it keeps on coming up in the stuff that I've been reading. And again, in WA, it's very clearly identified in our psychosocial hazards. And what they noticed and what they said was that management weren't trained to appropriately deal with psychosocial hazards, and there were inadequate control measures related specifically to bullying and harassment. So this is really important. At the end of this session, I'm going to give you some what do you need to know, like what are your actions. But right now I'm going to say one of your actions is, and we have been running training mostly this year, end of last year, with managers around psychosocial hazards. But your managers need to know, they need to know that they have to frame when someone comes to them and says, I'm not coping, the manager should get that list of 20 categories of psychosocial hazards and start to have that conversation through that list, right? Because that's the assessment that WorkSafe is expecting all managers to be able to do. We run training specifically on that. You can have a chat with me after, but I'm just letting you know that is so critical. Another example, this goes back to 2019. So again, it was before psychosocial hazards was perhaps articulated clearly. New South Wales Rural Fire Service, there was a bullying complaint about their regional manager. And what happened for this one is it took over a year to finalise. And so it is so important. Again, this will be one of your actions. When you're dealing with issues, you've got to deal with them promptly. It's so important that you deal with it as soon as possible. Otherwise, the delay in dealing with it can actually constitute a psychosocial hazard. And they also identified that there was inadequate policy. So you need to make sure you've got a robust complaint management policy and procedure, particularly related to unlawful behaviours, but then you've got a robust process around identifying psychosocial hazards. Example 3 is a WA one. So this is back in 2018, and this was Southern Ports. And they were issued 3 improvement notices related to bullying, allegations from their leaders. In the improvement notice, and it's public knowledge, I just went online and found it, they actually mentioned psychosocial risks in the improvement notice, and that was back in 2018. And managers failed to address inappropriate behaviours. Also, there was high work pressure and there was some unreasonable performance management from managers. So again, the theme around managers has come up in that improvement notice. And then the last one is not an improvement notice, it's an enforceable undertaking. So an enforceable undertaking is where WorkSafe and the PCBU agree to the PCBU paying money to WorkSafe in lieu of a prosecution, but that money has to be allocated to go back into programs related to education and improving the safety in workplaces. So in this example, it was back in December 2023, Fortescue entered into a $1.4 million enforceable undertaking for failing to supply documents relating to sexual harassment incidents at their mine sites. And the money was allocated to programs. So in WA, we had an inquiry and a report called Enough is Enough, which was specifically in the mining industry. And that money was allocated towards improving workplaces in the mining industry and carrying out some of the recommendations in the Enough is Enough report. So it just gives you an example of improvement notices and enforceable undertakings. I did want to mention that there's a couple of other ways that people can end up, that a PCBU can end up being liable or responsible for psychological harm of their employees or of their workers. And this one's a really recent one. It's actually only come out recently. It was in Tasmania. And this was so the case one in Tasmania was a workers' compensation claim. So it involved a teacher who worked at a high risk school with high school students. And that teacher had experienced incidences of violence from students directed at him. He'd also been involved in intervening in incidences of violence between students. And I think in one incident, there had been a knife involved. So he already had this history and this experience of violence. The school had students who were varying degrees of violent type behaviours, and they had made a decision to not, they had a decision to allow readmit two students back into the school who had a history of violence. And they hadn't put in safety measures in place and about how that was going to manage. And this teacher had expressed his concerns in relation to that, and those concerns weren't heard, they weren't acknowledged, they weren't addressed, and he suffered psychological injury as a result of that whole experience and process. He made a workers' compensation claim, and that was successful. And the workers' compensation claim talked about the PCBU's responsibility around protecting. So while that wasn't a WorkSafe, what we're showing is that an employer has to take into consideration psychological harm caused. And the employer argued that it was a reasonable management practice in reinstating those students, and the court that heard the workers' comp claim said no, it wasn't. The second case was heard or actually finalised in 2022. It actually went on multiple appeals until it ended up in the High Court. And this again is an idea of how long these matters can take, because the incidents go back to 2012. And this involved a lawyer who worked for DPP, so Department of Public Prosecutions. She was involved in prosecuting sex offenders in relation to crimes against children. So a lot of the content that she was exposed to was extreme, very graphic. She was a mother, and so what happened for her as a consequence of those exposure was she became hypervigilant in relation to her child. She ended up developing PTSD as a consequence of working in that unit. And she sued her employer for negligence for not providing a safe workplace. That court journey took a very long time and ended up in the High Court, where they said that actually the employer was negligent. And what was identified, and I guess for me, I find this quite tragic on multiple levels, is the employer actually had a vicarious trauma policy. Nobody knew about it, and it hadn't been applied and used. And if they had applied and used that vicarious trauma policy, it may have significantly reduced the harm to her and perhaps other people in that workplace as well. And so that's, again, an example of you've got to have more than just a policy, right? You've got to actually use it, implement it. This gets back to step 3 of safety, which is how do you minimise those risks? So a few stats, not very happy stats, I might add, but 37 weeks off work. So Safe Work Australia, stats related to, I think it's the 2022-2023 year, says that for a serious mental health claim, on the median is 37 weeks off, and yet for a serious physical injury, the median is 7 weeks off. So when I read those stats, even I was shocked. I was not expecting such a significant difference between the two. So 37 weeks off for someone who suffers a mental health claim. A European stat, and this one came out this year, report from last year, is that they have estimated or calculated that 10,000 people die each year through work-related stress and suicide. So they've put a number on that. And I think the contrasting number was something about 3,000 something people died through a physical work-related injury in Europe. And PricewaterhouseCoopers, they've done a report. They love doing these kind of things. And they said, if you invest $1 in mental health programs, in good mental health programs, in ways to take care of your people, then you're going to get back $2.30 in benefits. And so we think, well, what does that look like? Well, because people are functioning better, they're not taking sick leave, they're not taking absenteeism, presenteeism, and so you've got a fully functional, healthy workplace of people. So lessons from the cases. So if you haven't done a whole of organisation risk assessment, you need to do it. I don't do that stuff, but there are people out there, and I can give you some names of people if you want to know them. You're using the 4-step process. What I would say for all of you is you've got a code of practice on psychosocial hazards. In WA, it steps out the 4-step process for you. We also have an international standard, the ISO, in relation to psychosocial hazards. And so you could also be looking at doing that. What they're saying throughout it all is make sure you consult with your workforce as part of this. So consultation is really important in the process of addressing psychosocial hazards, and make sure you implement a hierarchy of controls. So best practice is to stop it. If you can't stop it, what can you do to eliminate it? Make sure you've got clear policies to identify unacceptable behaviours and clear reporting processes. So many of the times people don't know what to do, they don't know who to go to, and also they don't feel safe, which is number 7. So you've got to make sure that you've got safe reporting systems. It's not enough that you've got a complaint management process. How do people access it? How do they feel safe that they're not going to be victimised, they're not going to be punished because they've made a complaint? I know a lot of my workplaces now have various ways of anonymous reporting, or you can log in and report. You don't have to identify who you are, but you can have a dialogue through that logging in system. So for example, HR can come back to you and go, tell me more about this, and you can choose to engage with them without them knowing your identity. So it's really important to work out how safe is your reporting system. You've got to provide regular training, people. So I go into workplaces all the time, and most people are scared of the terminology around psychosocial hazards. You have to demystify it. It's not that scary once you understand the code of practice and you understand what to do about it. And again, the improvement notices and the case law is saying your weakest link in some ways is your managers. Now, I define anybody to be in a position of authority as a manager. So as soon as you are supervising somebody else, you've got an extra duty of care to be able to identify, wait a minute, that doesn't sound okay, and to have that conversation to work out what's happening with this person. Does it fit within the space of psychosocial hazards, or is it something else? And so that's a really important skill set that managers need to have. And you've got to respond promptly to complaints. Specifically not under WorkSafe, but under the Respect at Work Act, one of their guiding principles is around having human-centred and trauma-informed investigation and complaint processes. Now, part of that is making sure you work with the person and you don't do the process to them, but part of that is how quickly you address it. It's not rocket science to work out the longer a matter is dragged out, the more difficult, uncomfortable, traumatic it could be for the person who's kind of stuck in this limbo. Where to from here? Oh, I don't know why. Let me put them all up. Go back. Where to from here? So if you haven't done the organisational risk assessment, do it. Find someone who can do it. Do it yourself. You've got the ISO one. Safety and HR, and I've said this before, I'm going to keep on saying this every time I run training, I say it. Safety and HR need to meet regularly and collectively decide how issues are identified and managed. No longer do we have safety over here and HR over here. You are now a team and you need to be talking to each other regularly. I think you need a funnel approach, and then you can say, okay, here we've identified, and now safety will go and do this bit, or HR will go and do this bit. But you need to be collaborating, talking, understanding that you are dealing with the same issues, because safety now can deal with everything, right? Safety can deal with all of the unlawful behaviours that perhaps people and culture and HR used to manage. Train your managers to look at workplace issues through the lens of psychosocial hazards. Come and talk with us if you want to know more about that. I've created a really simple, I am not a complex person, I've created a really simple 2-page note-taking template that we are giving out to managers when we run the workshop. And it literally steps them through the 4-step process: identify, assess, eliminate, and how do you maintain and audit. And so you need to train your managers. And lastly, ignorance, lack of time, and lack of resources is no excuse. Actually, if you're big, then they're going to expect more of you. So the bigger you are, the more money you have, the more resources available to you. They are going to expect more. But you can't say, I didn't know, no one told me, because that's just not going to cut it. And if you haven't already had enough reasons, actually within our safety legislation, and I was having a little wander through our Work Health and Safety Act and the regulations, and there's actually a component in here which says you have to provide information, training, and instruction. So it has to be adequate. There's a penalty if you don't do it. And over here, it has to be readily understandable by any person to whom it is provided. How's that for making it even harder? Look, at EO Specialists, we do pride ourselves on creating training that is readily understandable. For those of you in the room that have used us in the past, hopefully you would agree with that. We do have an interactive theatre experience on psychosocial hazards, which people are loving, learning from, telling us after we've been with them that it's creating follow-on conversations, and that's really what we're about. We might be starting the conversation, but we're wanting to create follow-on conversations for your people, your workers, so that everyone takes collective responsibility for psychosocial hazards, that they feel like they can speak up, that they can contribute, that they can be involved, and also specifically for managers, that it demystifies what is this and what am I supposed to do about it, and that they don't feel overwhelmed by actually having to have those conversations with their staff. So I'm going to have a look at the chat. If you want to ask, I know we've got 3 minutes left. We'll be sharing the pack, and could you please share some further information on the 4-step checklist? Yes, I tell you what, I can send you the PDF of my note-taking template for managers. Can I say, though, if you just hand this to your managers and say, here, use it, that's not fair on them, because it won't make sense to them, right? So I'm sending it to you so you can have a look at it, but you need to be training your managers on how to go through this process. But I'm happy to send you that after today. Anyone want to ask me any other questions? Otherwise, you can say something in the chat. I'm an extrovert. I love to hear from people. It's always hard in a webinar of 1 hour and lots of people, and I know it's me talking at you. I hope that this has been useful. Contact me if you want to have a conversation after today about psychosocial hazards. It doesn't have to be as hard as it currently is. We've got a whole lot of good resources that we can use to train and support your people. Go well, everybody. Stay safe.
There's a question in the chat. Is it still okay to use
sex-based harassment? Yes, absolutely. Sex-based harassment is a legal definition. It's in our federal laws. It still applies to WA. So even though our code of practice doesn't specifically articulate it, it's still part of the legislation. So I would be saying, yes, you in fact have to use it. Thank you for the question. Anyone else wanting to ask a question? Otherwise, we'll say goodbye.